The same issue. All right, thank you. It's 5:15, so we'll go ahead and get started. This is the May 2025 meeting of the City of Charleston Board of Zoning Appeals and Zoning. Present here today are Howell Morrison, Robin Richards, John Bennett, Chappie McKay, Gordon Huey, and me, your chair, Jeff Tibbles. Present from the planning staff are Craig Bennett, Robert Summerfield, and Matt Slagle. These proceedings are being recorded, and we ask that those who speak please identify yourself for the record. We will conduct this meeting in the usual fashion. We will first receive information from city staff about the application and their recommendation. If the recommendation is favorable and no one objects to the application, the matter is uncontested. The Board of Zoning Appeals usually, but not always, approves uncontested applications. For all applications, the board reserves the right to ask questions of the staff, applicant, or others in attendance prior to rendering a decision. If, however, the city recommends against the application, or if there is opposition to the application, we treat the matter as contested. And we hear from the applicant and anyone else who is in favor of the application. Next, we hear from anyone opposed, followed by a short rebuttal from the applicant. We then close the public hearing portion of the meeting for that particular application and open discussion to the Board of Zoning Appeals members only. We will then make a decision to approve with conditions, or deny the application. The Board of Zoning Appeals zoning has the authority to do three things. Number one, hear appeals to decisions of the zoning administrator. Number two, grant special exceptions, a fact-finding function of the board. And number three, grant variances to the zoning ordinance if the application meets the hardship test outlined in section 54-924 of the ordinance. The board may deliberate and make a final decision on a matter by a majority vote of members present at the hearing or qualified to vote, provided that not less than a quorum is present and qualified. However, an affirmative vote of 2/3 of the board members present and voting shall be required before a use variance may be granted. For a variance to be granted, the Board of Zoning Appeals must make the following findings. A, that there are extraordinary and exceptional conditions pertaining to the particular piece of property. B, that these conditions do not generally apply to other property within the vicinity. C, because of these conditions, the application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. And D, the authorization of a variance will not be of substantial detriment to adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. I'm required by our city ordinance to swear you in if you intend to speak tonight. So if you do intend to speak, please raise your right hand. If you swear to tell the truth, the whole truth, and nothing but the truth, you'll signify by saying, "I do."
I do.
Thank you. We don't have any deferrals on the agenda this evening, but Mr. Summerfield has a couple of announcements. One, to introduce a new member of our planning staff, and second, to inform on participation by Zoom by a couple of folks. So.
Thank you, Mr. Chairman. So just a couple housekeeping items. First off, I would like to introduce everybody to our new senior planner, Matthew Slagle. He is joining us from the state of South Carolina Department of, I don't know, they keep changing their name.
Environmental
Services. And so we are very happy to have him. He will be serving, for all of those of you who've worked with Ms. Penny Ashby in the past, he will be serving in that role, helping to support the Board of Zoning Appeals zoning. And once again, we're very thrilled and happy to have him on board and take that effort off, especially since Craig is abandoning us to go spend a year in the Middle East, keeping people safe from missile attacks or something like that, I think. I don't know.
Wow.
Yeah, he gets to go play war games or something. Sounds scary though. And then secondly, we do have two participants for item, I believe it is the last item on our agenda this evening for item B3 519 Rutledge. They will be available for the board to ask any questions. They last minute couldn't be here, so we've allowed them to join Zoom, which is not our normal practice. But we did want to make sure that if the board does have any questions for that applicant, when we do get to that item, that they would be available to respond. So they are on Zoom. at the board's discretion on whether or not they have any questions for the applicant when we get to that item. And that's all, Mr. Chairman. Thank you.
All right, thank you, Robert. All right, we'll go right into the agenda. Item A, review of minutes and deferred applications from previously advertised BZA-Z agendas. The draft meeting minutes have been circulated to you, board members, and your packet of materials for this meeting. Number one is review of the minutes of the April 15, 2025 board meeting. We do have a quorum available to vote and approve those minutes. Is there a motion? All right, Mr. McKay moves second. All right, Ms. Richards seconds the motion. All in favor, please say aye. Aye. Any opposed? None are opposed. The motion passes unanimously. For the record, the voting parties in favor are Robin Richards, Chappie McKay, Hal Morrison, and me. The next item on the agenda, so those minutes are approved for the April 15th, 2025 board meeting. The next item on our agenda is A2, review of minutes of the May 6th, 2025 meeting. Again, we do have those meeting results that have been circulated to the board members. Do I have a motion? All right, Mr. Bennett moves. Is there a second? All right, Mr. McKay seconds the motion. All in favor, please say aye. Aye. Any opposed? None are opposed. The motion passes. For the record, the voting members are Robin Richards, Chappie McKay, John Bennett, and me, Jeff Timmons. All right, the next item on our agenda is B3. I'm recused from this one, so Mr. Bennett's going to handle it. Yes, as the chair of my stead. Thank you.
Thank you, Mr. Hills. A3, 28 Hazel Street, Anson Borough Council District 8, TMS number 4580501, 174, 175, 176, and 031. Zone LB request a special exception from section 54-511 to allow 21 square foot of office space without providing parking. 5 spaces required. Owner is, as here, Hazel Partners, but it might be Hazel Partners LLC. Applicant is Brian Hellman. Mr. Summerfield.
Mr. Chairman, so I want to first off start by there are some corrections for this item that have been made. The applicant has updated the floor plan to address some deficiencies in some of the labeling of the areas per our parking standards. We only count the actual office space when calculating the office parking requirement. And so when they updated the floor plan, labeled everything, it's now in 1,997 square feet of office space, which would require 4 parking spaces. This is a reduction in the request, and therefore the legal ad is still valid. All the advertising on this is still valid. So I just want to make that correction for the record. So again, this is a deferred item. So we've the board has heard about this item before. We've actually, the board heard an item for this property within the last year, again, with a parking reduction. As you can see on the site plan here at the corner of East Bay and Hazel, that this property is essentially almost 100% building with no access to be able to provide any on-site parking on the property. Here you can see the aerial and see here on East Bay. You can actually see on East Bay in this aerial at least some of the on-street parking on East Bay, which is outside of the neighborhood. That will be important in a few moments. Again, this is a request for a special exception, not variance, so it does not have the same threshold test that we would have for the variance test that the chairman outlined previously. Again, here you can see hopefully the floor plan. This is the adjusted floor plan that shows the updated square footage and appropriate designations and uses for each of the spaces. I'm happy to blow that up bigger if anyone needs me to. There was a letter from the Historic Anson Borough Neighborhood Association indicating that they were opposed to the request. Again, Hannah has indicated, and I'm sure there will be members of the community that will come up. Their biggest concern is that any parking related to this location would overflow into their residential street parking that is on Hazel Street. Again, staff's position is this is a building we want re-tenanted as a city goal to keep our buildings in our historic areas useful, being used. The proposed use is very modest in terms of the request. It's an art gallery, art studio by appointment kind of thing. It's not like a retail art store like we have in other areas of downtown. From the standpoint of, people will just be walking down the street and say, oh, this is, let me go in, like you see on Broad Street and King Street and some of the other areas. Again, the request for parking here is very, I'm sorry, I'm confusing this with a different one, so disregard that last part. It's an office. At any rate, staff is supportive of the special exception. Again, this is not a variance. It doesn't have the variance level of scrutiny to it. There is publicly accessible metered parking on East Bay that is well within the block or so radius of this property. We feel that that is going to be sufficient to allow the use of this space as an office facility. And with that, staff is recommending approval of the special exception.
Thank you, Mr. Summerfield. So the city's recommendation is for approval. I suspect there are folks here in opposition. If you raise your hand, anyone here? Yep, okay, you'll have your moment in just a second. Let's hear from the applicant first.
Mr. Chairman and members of the board, my name is Brian Hellman. I'm at 105 Broad Street. With me here tonight are Brea Hamill, immediate left, Brooke Irich, and Chris Anderson, who are involved with this project. Brea is going to make this space her interior decorator, interior design office. So it is not an art gallery. It will have some showroom space in the front, but it will operate as an interior design, interior decorator office. We're here tonight for, as Mr. Summerfield said, for a special exception under 54-511 of the off-street parking requirements under the city's zoning ordinance. And what the purpose of that ordinance is to basically approve that this board can approve a reduction in the number of required off-street parking spaces in certain instances. And there's effectively 5 elements for us to meet. And that's what I'd like to go through with you. The first is the first element is whether the proposed use is an allowed use. And the property, as Mr. Summerfield said, is zoned limited business, and an interior design decorator office with a lesser portion of showroom retail gallery is a permitted use under the limited business zoning district. The next element is whether the existing building is configured in the lot or existing buildings as configured on adjoining lots make it feasible to provide off-street parking. And I think as Mr. Summerfield showed, this building that has been around for much longer than I think any of us in this room goes effectively lot line to lot line on Hazel Street and lot line to lot line on East Bay, and pretty much fills up the whole property. There is no real access without going through the front piazza door to get to any green space, and that space that's available is too narrow for any car to fit through, but not a bicycle. So given those boundaries, the second part of the test is infeasible to provide any parking on the existing property. The third prong is whether street frontage of an existing lot is so limited that a driveway for access would be unreasonable or would impractically reduce the area available for occupancy. And again, it's street frontage to street frontage. There is no space for a driveway given the boundaries of the property. That floor plan that you're seeing doesn't show the staircase to the second floor, but I think if Mr. Summerfield, we go to, you had a nice zoning map, I think that, there we go. That has a good footprint of the building. Then the next element is whether the special exception will adversely affect neighboring properties. And I think this really addresses the question that or the comment that the neighborhood association had. We're here sort of for a unique set of circumstances. This building had been grandfathered for office uses. It was Charleston Blueprint, and then it was a number of different gallery and interior decorator uses up until 2020, when it became a law firm. Still grandfathered for parking. But when COVID came, the law firm ceased operating out of this space. And when it ceased operating and did not renew its lease, its landlord fell upon hard times and the property then got tied up in a foreclosure action. During that period of time, the 3 years in which a grandfathered property can maintain its non-conforming use expired. And so had Brea come around about 6 months ago, maybe 7 months ago, we would not be here tonight. But because of that passage of time, as a result of COVID and the foreclosure, it extended that period out. Which is why I guess we're here. So the question then is, well, if that's been around for all this time and we're really asking for what's there, basically, pretty much, it should be perfectly fine for Hazel Street. But the neighbors had a legitimate concern. They said, well, you know, if you have this use, people may park in our space. But if we don't have this use, the only other use this property really ends up with is a residential use. And the difference between this office use, which does not get any residential permitted parking, is that a residential use gets the use of 2 permits per unit on Hazel Street. So the alternative of switching to a residential versus a commercial would actually be more detrimental to the neighborhood and, or I'm sorry, adversely affect, using the word of the ordinance. So we think that this use would not adversely affect the neighbors. And in fact, the commercial use is a better use because it doesn't have access to the residential parking stickers. Lastly, the last element of the test is whether the applicant has pursued good faith efforts to provide off-street parking. And at the time we submitted this application, Brea had not been able to find any off-street parking. And as you may recall, if we could find within 400 feet of this property a 10-year lease, we would not have to come. But within 400 feet, there was no 10-year lease available. Nobody wanted to lease parking. The closest property that was found is in the Spoleto lot where Brea is able to sublease on a year-to-year basis 4 parking spaces. And you know, as long as that landlord is willing to continue to renew those leases, there is 4 parking spaces that are available. What the neighborhood has asked is that her business license be conditioned upon basically, if she loses that parking, finding more parking. And I can assure you all that this group has worked tirelessly to find those 4 parking spaces. And with what's going on in other parts of the city, the likelihood that that could or could not happen and the cost that it would cost would make it almost impractical. So much so that the best option, if that was lost, would be to just provide, you know, reimbursement for hourly parking in the garage at this building, which is the closest city parking garage. We asked the city, they do not lease monthly parking spaces at this time. So it would have to be an hourly parking space, and Brea has agreed that she would reimburse her employees, where she expects to have 2 of them there in addition to herself, for the cost of parking. And that to me would be a fair condition, that she would agree to reimburse her client, her employees for their cost of parking, or an alternative thing like a car to bus, or if they, ride their bike or what have you. But to do what the neighborhood was asking and condition a business license is really the death knell for this property as any type of commercial use, because nobody's going to make any investment whatsoever, knowing that some random landlord has control over your destiny. I think that goes through the 5 elements and why we think we meet them, but I'm happy to answer any questions, and Brea is here as well to answer any questions that you may have.
Did I understand correctly that you do have the 4 parking places secured for a year?
They're year-to-year spaces, and they are available for her lease if this use is approved. Yes.
So if the lease is approved, she will take those
She will
4
take those.
spaces
She will take those
on a
spaces
year-to-year basis.
as long as the landlord allows her to keep those spaces. Yeah, I mean, she's taking them. But our concern is that they're a sublease from Spoleto, who leases them to someone who then subleases them to her. Spoleto can not renew those. The sub landlord that she has may not renew them, and that's, you know, a risk here. And you know, as the neighborhood was requesting, that her business license be tied to some third party's decision. I hope that helped answer the question.
Is 4 spaces sufficient for the staff?
So the staff, it's Brea and 2 others that she's hiring, but the great thing about this property, and it's sort of unusual, in addition to staff, there's so much metered parking available all the time, it seems, certainly on Washington Street and even on East Bay Street in this area. Unusually so. I mean, I have some pictures if you want to see them. During business hours, it was literally a ghost town of parking. It's probably the only place left in Charleston where you can always find a metered parking space. I think that was one of the reasons that Brea was attracted to this property.
Thank you, Mr. Hellman.
Thank you.
Anyone else here who wishes to speak in favor or on behalf of the application? If not, we'll hear from opposition. Well, one handed up. Please come on up and state your name and address for the record, please.
Hi, good evening. My name is Jerry Shower, and I live in Anson Borough, and I'm currently president of the Neighborhood Association. And we did submit the letter, which you probably all read. We would update that to 4 parking spaces, if that's what you guys agree is appropriate for their use. They're required to have 4 spaces. If you give them a special exception, there's 0 spaces. They didn't ask for 2 spaces. They asked for 0. We acknowledge that a 10-year lease on a parking space is challenging. We'll just leave it at that. Our suggestion was acknowledging that to have them have annual leases and just prove that they have parking. Without something in place, it's great that they have parking now, but when that goes away, there's nothing to protect the neighborhood. Hazel Street has very few parking spaces on it. The neighbors that live there, many of them are here today, and some have been at the other meetings as well. They have driveways that are difficult or dangerous to come in and out of. Losing any of that parking for the use on this corner would have a negative effect on them. And I'm sure others will speak to how tight parking is over there. So we appreciate that the applicant and the building owner and their team have reached out. We always appreciate that in advance. We want you to be successful. If you're successful, there's going to be people there. People are going to have cars. And that's really our main concern here today. So that's why we have this position. Appreciate your time and respect your decision.
Thank you, Mr. Shower. Any other questions for him?
I have one question for you. The last request was the dental school.
Correct, the dental school.
We didn't like the dental school. I mean, there was just, man, it seemed like it was a bunch of people during the month. And it's hard to find what is that right fit. Do you think this is better than the dental school, or you don't have to answer if you don't want to, but.
Well, the dental school was, that was a kind of a very specific use, and their description was such that they had thought through a lot of things with it. This use is very different. It is more of an office use with it. I think that the feedback from the neighbors is that this would be a welcome tenant to have there. We just are tremendously concerned about parking.
Yeah, I get it.
Mr. Shower, I don't fully understand the concept of a dangerous driveway. I know those driveways are tight, and I used to live downtown with a tight driveway on a tight street, tighter than Hazel Street. And so it takes 2 times to get in a driveway like that sometimes, 2 times to get out. And you can't necessarily have a big car, but it's still a driveway. And the comment that you made suggests what I heard the last time this was in front of us, which is some people choose on Hazel Street and prefer to park on the street than in their own driveway. I heard that clearly last time. And I'm kind of hearing it implied from you, but it's hard to convince me that the driveways are dangerous on Hazel Street. Cars don't go fast up and down there. They'll wait if you have to pull in and pull out. It may be hard for an elderly person or intimidating for some drivers to do what they have to do to get in and out of their own driveways, but that's what they are there for. And I'm just commenting that way because people who don't choose to use their own driveways and take pride in getting a street spot because it's easier to pull in and out of, I don't have much appreciation for that. And this is the second time I've heard that. And this use they're proposing will, as Mr. Hellman said, will not give any entitlement to 2 on-street parking places. It's a commercial use, and it is a decent argument that it's going to be lighter impact on Hazel Street on-street parking than would a residential use with 2 guaranteed street parking places. So I don't mean to be aggressive about it. Y'all are being good about this thing, but something's got to happen with this building. You don't want the building, it's not in your interest, this building to sit there vacant in your neighborhood's interest, in my way of thinking. And I can't imagine a lighter impact use of this building than what's being proposed. And I mean, we all have to compromise, and it's going to be hard on them. They got to keep looking for parking no matter what. It's not going to get any easier, but you can't satisfy everybody in these situations, obviously. And I'd like to hear from this applicant also that they will make sure their employees do not park on Hazel Street if anything else can possibly be utilized. I'd like to hear that offered up as a condition of their application. But a compromise has got to be made here. And I don't know, those are just my thoughts. Thank you.
Thank you.
Thank you, Mr. Shower. Any other questions? Okay, we'll hear next from anyone else in opposition to the application.
Can you see me? My name is Jackie Meany. I live at 34 Hazel Street. I appreciate your letting me speak tonight. First, let me say that yesterday we met with the owners, their attorney, and a representative of the tenant. And depending on the answers to questions I have, you do have my letter of opposition that I sent before the first meeting. Depending on the answers to the questions I have, I may be withdrawing my opposition to the request. We would like to have a business there that is compatible with our historic neighborhood, and I think this tenant would be. But always there is the issue of parking. I won't correct you on getting in and out of our driveways. We get in and out of them so that we can let workmen come in or somebody else come in. So it isn't just getting in and out, but be that as it may, the owners and the tenant have told us that they've secured 4 spaces on George Street, but are not sure how long those spots will be available. My guess is they'll probably have them until somebody buys the lot and puts another 50-room boutique hotel on it. But I think most of us are willing to work with this tenant. My questions are, number 1, does this exemption go with the owner or the tenant?
It goes with the property. So as long as it remains in office use, this exception would apply.
Okay, so it doesn't, if the tenant leaves or when our lease runs out, they couldn't put a restaurant there or a vape shop or?
Correct. No,
Okay,
it would have to be
the
another
same
office
use.
using the same or less
Okay.
square footage than is currently indicated for this particular.
So I guess that answers my other question. If and when this tenant leaves,
Mr. Chairman.
what happens?
Yeah.
If this tenant leaves, then the owner of the building would need to, ideally, if they don't want to come back through this process, they're going to be looking for an office tenant that doesn't need more than 1,900 square feet of office space to re-tenant, because at that point, they don't have to come back through. They're going to want to do that within the 3 years, as is the complicating factor we have now with the loss of the thing. We don't want the period that this
Right.
is valid for to go away. So, but if they want retail, which would be the vape shop or something else, they want a restaurant. But
They have to come
dental
back.
school wants to come in and thinks that, again, this is the premium spot for that, they would have to come back
They'd
through and
have to
ask
come
for a
back
new
here.
special
Okay.
exception for the parking.
So my next question, you may have answered it, but how long is the life of this exemption if it's allowed?
It's as long as the office space is in use and doesn't
Okay.
go away for more than 3 years. 3 years, right?
Okay,
Yeah, 3 years.
and I'm taking a leap of faith and hoping all of the parties will live up to their assurances that they gave us last night. And I am removing my objection. Thank you very much. But until the city does something about the parking problems, you guys are our only protection. And we're grateful for the work you do, but thank you.
Thank you, Ms. Meany. Anyone else here in opposition? Yes, please go forward.
Christina Dodd, 42 Hazel Street. Excuse me, I'm also on the board, and I do object. I do also want to welcome these nice ladies. We've been very impressed with the presentation they gave us at the board meeting, and then again, the willingness to speak with us. The fact that they're willing to take 4 parking places, to lease those for a year, that shows good faith. So as long as that goes into effect, we would like to welcome you. Thank you.
Thank you, Ms. Dodd. Anyone else here in opposition? The owner and applicant have an opportunity to rebut.
Thank you. I mean, I think I probably answered most of what everyone brought, with the exception of Mr. Morrison's question, which I was able to check with Bria, and she is completely fine with a condition that would prohibit her employees from parking on Hazel Street. That was certainly not her intent. Confirm that as well. It's very difficult. I understand. My office is on the corner of King and Broad Streets. I have a very narrow driveway. I literally just got a new car that has the alert when you back out and tells you that cross traffic is coming, because you would not believe how fast people drive down King Street. Charleston is such that people used to wave, but nobody waves and lets you in sometimes. That aside, I think here, I hope that I've answered all the questions that you may have, and I hope that we responded in advance to the statements that were made.
Thank you, Mr. Hellman. Any other questions or discussion? I have maybe one question, Mr. Summerfield, for you, and that is, as it relates to the specific aspect of requiring, maybe this is really more of a question for the city's position with regard to renewing the annual parking leases and that restriction on their business license, and how that works from a mechanical standpoint. Like, is there a?
Well,
Yeah, that's really what I'm.
so it's difficult because our licensing process is, particularly for a use like this, is sort of a kind of an auto renewal thing. There's not a zoning review on it. So if that is a tack that the board would like to take, I would like to request that we don't tie that part to the license, and we just say you shall provide your parking lease annually to the zoning division of the planning department. So that they just have to update that and we can put it in the file and it's good to go, but it wouldn't be tied to their business license. What would then happen though, if they fail to comply with that condition, then they would be subject to having their special exception revoked because they're non-compliant with condition of approval. Alternatively, what I heard from members of the community, and correct me if I heard it wrong, really the community would, or at least the neighbors who spoke, would be okay with them demonstrating the good faith effort, demonstrating that they have leased the spaces for the year, understanding that it will be a year-to-year process. So if there were a condition that they have to demonstrate to the zoning division of the planning department prior to approval of their business license that they have leased those 4 spaces for a year, then that allows us to verify that the good faith demonstration that the applicant has made to the neighbors has been addressed and satisfied, but it doesn't have an ongoing reporting component to it. But those would be my suggestions or recommendations if the board is looking for something along that vein. But yeah, I wouldn't want to tie anything to a business license because that's really kind of an auto function because it's really just a revenue system once we approve the first license.
Thank you for clarifying that, Mr. Summerfield. And I think you've already answered my other question with regard to future tenants and how this special exception would carry over into.
And that would be the other reason why I would suggest that not doing anything that's an annual reporting, because that means the next person inherits it. But then what happens when there's a communication breakdown because they weren't the party that was here before the board that got that approval and something gets missed and then we're suddenly, it just becomes more complicated, especially, you know, with changeovers of tenants, changeovers of ownership, changeover of staff to kind of follow through on that.
Comments?
Could we have besides conditions you talked about or some combination of them, could we have a condition that after this expiration of this first 1-year lease, that tenant at least demonstrates to zoning on an annual basis that they have continued to make good faith efforts, whether or not they secure parking, that they don't just let the 1 year expire and not try again.
Yeah, we can figure out some wording real quick if that is a condition that you'd like to have, that they either must secure or be able to demonstrate to the satisfaction of the zoning administrator that they've made good faith efforts to secure parking within the 400 feet or so of the premises.
I think more than 400 feet over on George Street, okay? I think that'd be more than 400, but even still, to your point, it's to be.
And half a mile and
then we could have.
3 blocks, whatever.
If we could, I'd move approval with that condition and the condition that the tenant require her employees not to park on days.
That was the other one.
Unfortunately, stickers are coming back, so that will become a little bit easier to enforce too.
But those are
Parking
conditions.
So those
So-
two conditions.
Yeah.
The
Mr.
employees. So the employees can't park on Hazel Street. And the good faith efforts to renew the parking lease.
And I would just say that we expand it to within HPNA.
Share that good faith effort, not only with the city zoning administrator, but also.
But also-
The not parking on the street within HPNA.
Okay.
Unless it's a meter, because there's actually some metered parking in HPNA too, so they may be using metered, so let's say just public spaces or neighborhood spaces.
Not parking in the Hannah.
not parking at HVNA.
In the residential parking
No
district.
residential parking, thank you. That's why he says zoning.
No residential parking.
Just to confirm, on East Bay Street, we would exclude the parking on the East Bay Street where there's a loading zone and things.
Yeah, those are P spaces, yes, sir. Makes sense.
Be just strictly Hazel west of East Bay Street. Is that your expectation?
I think you could say HVNA residential parking is what we're saying, because P parking is not residential parking and metered is not residential parking. I think we're just saying.
Okay.
The residential parking.
So, Mr. Morrison, do you have any, you've made a motion with the conditions, and I think we kind of talked through them. I just want to make sure.
You better articulate.
Yeah, give me a second. I'm gonna try and make some notes real quick and see if I can state it more succinctly.
And just thinking out loud a little bit, I know you're doing a good job writing it down. When we talk about the annual effort to try to find parking. I'm just floating this out as an idea upon the request of HVNA to provide that
How
documentation.
about a letter to zoning on an annual basis by a certain date with the specifics of what they have done to seek parking?
Yeah, and we will attach that to the property record, so anyone can go on, we'll make it available online, so anyone who's interested in following up with that would just be able to do a search in our city system for the property, and they would be able to find that, correct? Yeah.
My only concern, Robert, is I don't want you to become an enforcement agency and having to reach out looking for these documents.
Oh, yeah, no. If we don't get it, then we're gonna issue them a letter saying that they have X amount of time to supply it, and if we don't have it by then we bring action before the board to revoke the special exception. I mean, we are technically an enforcement agency, and because the authority granted to this board, we enforce any conditions that you all apply to any approval that you give.
And that's why I was thinking that we put the trigger back on the community, that if there's a problem, then the community can let us know there's a problem, as opposed to us having to think every year, did we get the letter, not get the letter? But if you're fine with
Yeah,
that.
no, I think we want to get the letter, we want to put it online, we want to
Okay.
maintain a record for consistency.
Very good.
All right, so Mr. Morrison has made a motion for approval with the following two conditions. First, that employees may not park in the residential spaces of the Historic Anson Borough Neighborhood Association district. And secondly, that the tenant and or owner will make an annual good faith effort to secure 4 parking spaces and submit a letter to the zoning administrator on that effort.
Seconded.
Seconded by Mr. McKay. Any further discussion? Okay, all those in favor, please say aye. Aye. Any opposed? None are opposed. The motion for approval with conditions is granted. The special exception is granted, excuse me.
The applicant is good with all those conditions, correct? Always like to get that on the record.
Motion is 5-0. Mr. Tibbles is recused.
Yes.
Thank you very much.
Thank you.
All right, thank you, Mr. Bennett. The next item on our agenda under B, new applications, 1010 Ashley Avenue, Wagner Terrace, Council District 6, TMS number 463-08-01-109.
That's hard.
Zone SR2, requesting a special exception under section 54-110F to allow a second-story addition, primary suite, office bedroom, balcony vertically extending a non-conforming 2-foot 4 3/4 inch north side setback, 9 feet are required. The owner is Mandy Walters. The applicant is Abigail W.R. Brennan. Mr. Summerfield.
Mr. Chairman, members of the board, you can see that this is a mid-block property here in the Wagner Terrace neighborhood. The proposed addition would be mapped north on here on the property. As you can kind of see from this footprint, this is very close to the lot line, which is why they're making this request. The proposal, it's on the site plan here. Proposal would be to build out into this area that's kind of highlighted there. It would be to add a second story to this home. So you can see they showed some in the architecture board world, they'd call these precedent photos, and is showing another area existing addition, second story addition. Again, because of trying to meet the Board of Architectural Reviews requirement, which does have demolition purview only. They do not get to look at the architecture. They really only get to look at what is being requested to be removed from the existing historic materials. They do tend to request that those additions be pushed towards the back of the property, leaving as much of the existing conditions towards the front of the property as possible. Again, you can see two precedents. Prior to the board having review authority in this area, you can see that the actual neighboring property, I think it's the neighboring property, was able to actually do a two-story addition that basically eliminated the entire roof line of that original cottage there. All right, so we have the site plan here. Again, you can see with the color coding, they would be doing the second floor. As a part of that second floor, they would continue the existing setback on that north side so that that extension would be able to accommodate their remodeled interior, which includes some upgrades to some interior where the bedrooms are currently located, adding those stairs, and then adding essentially a master suite on the top floor of or the new second story of this proposal. You can see on the bottom the existing elevations, on the top the new elevations. I think at one point there were drawings that did not show the gabled roof with the 3 windows. This was a revision, I think, based on some comments that they had received from the neighborhood and honestly some concerns from staff. The original elevation should be noted that part of the problem that they have with this second story elevation is unlike you would normally see in most houses where you would orient that upstairs to the front of the house. So you would have windows. As you can see in the floor plan, that portion of the second floor is actually where they're going to have their closets and their shower, which obviously makes that difficult to put, the normal windows that you would expect to see in the front of the house. And then you can see how they address the rear. Again, this is a special exception for extending the existing setback. Staff did have some original concerns with essentially neighborhood character, not so much a number of the other elements that we look at with special exceptions, but we were somewhat concerned about how this elevation, the size, the way the massing, again, Board of Architectural Review would not look at any of that, but how that might impact neighborhood character. However, we did request that the applicant get letters of support from the neighborhood association and the immediately affected neighbors. They did do that. In your packet, you have a letter from 1012 Ashley, 106 Ashley, and we got a late addition to your packet from the Wagner Terrace Neighborhood Association, as well as the owners at 137 Darlington Avenue. So with this, while staff has some concerns about the front elevation and the presentation to the street, and does that disrupt the character of the neighborhood, given that the neighborhood association and the neighbors seem to be in support, staff is supporting the special exception.
All right, thank you, Robert. Do we have anybody who is here in opposition to the application for 1010? Okay, we'll hear from you in a moment. Do we have the owner or applicant present? All right, please come up and tell us about your application. Please state your name and address for the record.
Good evening, I'm Abigail Brennan. I am the designer and ground architect owner, Maddie Holders. We did meet with the Wagner Terrace Neighborhood Association last night, and if there are concerns about the elevation, we did tell them that we were going to fine tune it a little bit more. With the roof line, what we're trying to do is minimally impact the most north neighbor. And so that's why we have the lower roof line there. And then the neighborhood association really wanted windows on the front, which, yes, the attic is really low. So if we did have normal windows, they would be cut off by the roof. Or it was just really tight. And believe me, I played around with a lot of variations, and that's why we put the closets and the shower in the front. So we wouldn't need to have windows per se, but so we did put windows on because Wagner Terrace neighborhood wanted them, and I think it added to the facade as well. And I know that this design is growing from the first version that we sent you all, we are just trying to accommodate HVAC inside. It's a low attic, so it's just getting the height lines. The lowest ceiling roof is at 7'2". That's the low part of the ceiling. And then we're just accommodating attic access for storage because it is a very small bungalow. It's less than 1,000 square feet. We're on a very tight lot. Lot minimums are 6,000. This one's like 4,700. We don't have room to build in the back. So our only opportunity is to go vertical. And we do plan to talk with before we go to BAR, I do plan to talk to the Preservation Society and Historic Charleston Foundation to get their support and see what we can do. We are keeping the roof eaves, and my client and I both want to keep the integrity of this cute little bungalow, but it just doesn't work for what they're trying to accomplish. It's only a 2-bedroom, 1 bathroom, and it just doesn't function in today's world, I suppose. I think that's it for now. Thank you.
All right, thank you, Ms. Brennan. Do we have anybody else to speak in support of the application? All right, question for the city real quick before we hear from the opposition. We don't have an action item on the height, do we?
No, we don't have any request relative to the height. This is the SR2, which allows for, well, this height district is to, I believe we're in the height. I know we looked at it.
Yeah.
Unfortunately, Craig was on training for his upcoming med trip, so he didn't help us with this diagnosis, but we looked at the height. I don't believe there was any questions about the height.
Okay, so this is just
For the height district.
simply a vertical extension.
Yeah,
on
just a
setback.
vertical extension on the setback.
All right, we'll hear from you.
Good evening, Anna Catherine Alexander with the Preservation Society of Charleston. We really appreciate the applicant's willingness to speak with us about this project, and we hope for that opportunity in the future.
However, at this time, the Preservation Society shares the concerns that Mr. Summerfield expressed initially in his remarks, and we are opposed to this request that represents an unreasonable intensification as defined in section 54-110F and would have detrimental impacts on the character of the Wagner Terrace neighborhood. In considering the reasonableness of a request under this section of the ordinance, the board is required to consider the effects on properties in the vicinity and in particular impacts on the aesthetic character of the environs. The proposed addition is significantly out of scale with the streetscape, where two-story additions to one-story buildings are an anomaly and would result in an unreasonable intensification of the non-conforming use. The Preservation Society is confident that there are less intense solutions to gain additional square footage while respecting the character of the surrounding context. Potential options include pursuing a linear rear addition, which we do understand may require zoning relief, or a sensitive dormer addition, both of which are more in keeping with the architectural patterns of the neighborhood and are regularly reviewed by the BAR. So we would ask the board to deny this request as proposed and appreciate your consideration. Thank you.
Thank you very much. Appreciate your comments. All right, anybody else wishes to speak in opposition? All right, you have an opportunity for rebuttal if you'd like.
So we do have immediate support from the neighbors, so that's a huge thing. And the neighborhood understood that the design will fit the neighborhood. And then I did include the precedents. 139 Darlington is a spitting image of what we're trying to do. Same exact lot size. The one before. Yeah, so they're on top. So you have the front porch, you have the small bungalow, which has a really low attic. And then they were able to even build in their back, but they eliminated half of their roof. We are only doing, we're doing 2/3, but we can't build on the outside of it, and they bumped out to the back. So their massing is a lot larger than what we're doing. Don't know the square footage offhand, but our addition at the end is only gonna be 1,700 square feet, which is pretty small for the neighborhood and the other homes in the neighborhood. And not to mention the neighbor next door that obliterated the entire roof. And it's a different house, but I think just working with the character of the neighborhood and fine tune the designs. And I know that we're gonna go to meet with you for BAR. And I know that we have our hurdles with the Board of Architectural Review. I'm not naive about that. We just want to get this through to the zoning, just to know our limitations and just knowing that the highest part is 21 feet. And that's where the end of the setback is no longer encroaching. And we did look at doing dormers. Again, the attic is so low, it's only 4'5", so you can't even potentially do a dormer. So I just hope that you guys, that you all have the flexibility to know that what area is in the zoning that we're trying to approve is really not intensifying the lot, and thank you for your time, appreciate it.
Okay, thank you, Ms. Brennan. Do we have any questions of the city staff or of the owner, applicant, or the Preservation Society?
I have one.
No, you go ahead.
Well, I was just generally curious, if you pop back up to maybe the floor plans, I want to get a little bit better understanding. I'm trying to understand the attic that's in that space. It seems like that maybe was driving some of the windows, the 3 windows on the front elevation are not for the living space, but for the attic space.
And
I
the
think-
settings
And yeah,
from the street,
yeah.
and they are big help.
No, I agree,
Yeah.
but I think that's part of maybe what's driving the roof line so far up is having that attic space. If you didn't have that attic space, and you just had living space, and obviously that changes the interior. I think the character looks a little bit wonky, but as far as the special exception goes,
Yeah.
just if we're considering truly just the setback issues, I don't know that I have an issue with that, but I do think they're gonna have a hard time.
I have to say, I'm sympathetic with preservation about character of the neighborhood because I can see everyone with a bungalow house in there wanting to do something to expand wherever those houses are, and there are a number of them in that neighborhood. And so the neighborhood associations don't want to have their homes restricted, so they support them. City is now going down a path of supporting this on a basis that's going to be neighborhood wide, it sounds to me, and it's the whole neighborhood full of these kinds of expansions is going to look strange to me. But if the neighborhood wants it and the city wants it, I guess Preservation Society's taste, my personal taste in these matters, I don't matter, but it's a strange situation where the neighborhood association hidden behind Preservation Society's viewpoint on this, to me. And I feel like if a person can't live in a little bungalow house that size, I also agree with that point. You need more space, so it's a conundrum to me.
Mr. Chairman, if I may, I want to be very clear. Staff's recommendation is for the special exception to allow the vertical extension of the setback. We are still not thrilled about the architecture, but given that the neighborhood association and the directly affected neighbor, and it's a special exception, not a variance, so it doesn't have the same level of scrutiny. That is why staff did this. And I do want to be clear, these special exceptions and variances that come before this board are case by case basis. And so nothing is precedent setting.
I know
that's
when the
always
next
important.
applicant comes, they take your last two
I know.
recommendations and they have them on the screen and say, city likes these, they've approved them before.
And this
Well-
doesn't go to BAR.
The
I think she
architecture
said it
doesn't,
does.
the demolition does.
Right.
So to be clear, it will go to BAR small for the demolition of the roof to accommodate the addition, but the actual architecture of the addition does not go to BAR.
Right.
So they would not be reviewing the new stuff, they would only be looking at the damage to the removal of the old stuff.
So we back to the essence of the request. When I look up here and at the top, we're talking about the extension of a non-conforming. So we're really talking about that yellow square at the very top on this picture,
We are talking about the blue,
the blue.
yeah.
Okay.
Let me see if I can zoom in their footnote here.
Yeah.
I tend to agree with you.
Yeah, see, the yellow is kind of the deck, so that's not really the
So the
thing.
yellow and the deck doesn't count.
Yeah, the
So
blue is
the-
really, the area of what you're approving. It's the allowing that encroachment into the setback to go up.
Well, let's not talk about go up because we don't know what up is, because we're not talking about up, but we're talking about extending the house all the way over to that side. Now, what they do other than.
Oh, no, you are talking about up, because the house currently goes there. So what you are approving is the fact that their encroachment now will be at height versus just where it's at right now. So the house actually goes along that,
So the house travels to that property line.
yes.
Okay.
So that part of the house is existing. If I go to the floor plan, so you look at the existing, that part of the house remains where it is, and then you look at the proposed. They're reconfiguring the deck back there because they're bumping out this portion for the new
Okay.
laundry mudroom thing. But then when you look at the second floor, now this is where you're doing, this is the crux of the special exception, is that the area in blue on plan right, that's the vertical extension. So that area is within the setback, and therefore that's what they have to come to this board for. If they weren't doing that part, they actually wouldn't come to the board. So if they were doing everything else in the picture except for the blue and the green, because that deck would have a balcony, so since that has a roof, that's a thing, but if they were doing all of that, again, if they had the lot area, it is a smaller lot as was mentioned. they wouldn't be before the board.
But since the green area is gonna be conditioned in enclosed space, they would have to come back and ask.
No, the green area isn't enclosed, it's just a balcony, it's a roof over the deck with the ability to walk out onto it, it's a second floor element.
Okay.
But not conditioned space.
As your chair, I will do what I often do in these situations, and that is actually publish the standards. Also known as, Hal knows this, whenever my associate comes in, says, can we do this or that? The acronym is RTFR, which is read the freaking rule, right? So here we go. The non-conforming use of a building or structure cannot be physically extended to provide more area for the non-conforming use, and the number of bedrooms in a non-conforming two-family dwelling or multi-family dwelling use cannot be increased unless the Board of Zoning Appeals zoning, after duly advertised public hearing, finds that the extension or increase of the non-conforming use is, number one, limited to extending or increasing the non-conforming use then in existence. Okay, we got that. Number two, would not result in an unreasonable intensification of the non-conforming use. That's what we're discussing. And considering the reasonableness of the intensification of the extension or increase, the board shall consider the effect of the extension or increase on properties in the vicinity to include traffic impacts. Don't think we're worried about that. Vehicular and pedestrian safety, not worried about that. Parking impacts, no. Potential impacts of noise, lighting, fumes, or obstruction of airflow or light to an adjoining property. I don't think we're there because we've got consent. Impacts on the aesthetic character of the environs, and that was the standard that was enunciated by the Preservation Society, to include the possible need for screening. If an extension or increase is permitted, the board may impose reasonable and appropriate conditions and safeguards for the protection of the public interest in neighboring properties, including but not limited to limitations on days and hours during which the proposed use will be operated. That's not for us. And shall require for properties located in the old and historic district that exterior alterations be approved by the Board of Architectural Review, regardless of whether said alterations are visible from a public street or thoroughfare. So we can, if we so choose, require, and maybe we read this as we must, require that the Board of Architectural Review approve any exterior alterations that are in connection with this special exception.
I don't think Wagner Terrace is in the old and historic district.
Well, I don't know that we can't impose that condition anyway.
You're right, you can reasonably impose any condition you like. You're correct, sorry.
Just a thought.
Mr. Tibble, Mr. Chair, is your take on that we could, within our rights, require that this addition be subject to not only the Board of Architectural Review for demolition, but also for
I think we can.
design?
I don't, until somebody tells me that we can't, I think we can impose that condition. I think it's reasonable. I think it's consistent with the spirit of the, it may be true that technically Wagner Terrace is not in an old and historic district as defined by ordinance. At the same time, it may be a reasonable condition to impose. Board of Architectural Review may not appreciate one more application, but I think they may want to hear this one.
I personally like the idea. I'll make a motion.
I'll second
That condition.
I'll second that motion.
All right, so we got a motion on the floor that is to approve with the condition that the exterior alterations are to be heard and approved by the Board of Architectural Review. Any further discussion? All in favor, please say aye.
Aye.
Any opposed? None are opposed. The motion passes unanimously, and the application for the special exception is approved with the condition that the Board of Architectural Review will review and approve any and all exterior alterations to this property in connection with the project. Thank you. All right. The next item on our agenda. B2, 2 King Street, Charlestown, Council District 8, TMS number 457-16-02-060, zone SR3. Requesting a variance from section 54-301 to build a generator stand with a 0-foot north side setback and a 30-foot front setback. 6 feet and 60 feet are required. The owner is Cynthia Corley. The applicant is Alyssa Britton. Mr. Summerfield.
Mr. Chairman, members of the board, so I will point out, we do have an ordinance going through the council process. In fact, it'll be on council for first reading and public hearing next week that will hopefully take some of these requests for variances related to generator stands off the board's plate. However, this one, because it's requesting a generator stand that would be 0 feet from the side setback, would not be eligible for that. So that's why this one is coming before you now as a part of on this request. So as you can see in the aerial here, it's property on King Street. The footprint doesn't really do justice to the fact that there is just really not a lot of space on this site that you would put that. You can see here on the sort of the plans that were provided. Unfortunately, they weren't great. They're photos of plans. But you can see where the generator stand would be on this property. Again, there's not really anywhere that they put it. It's going to be really close to that property line. You can see the existing HVAC stand is again pretty much in a similar position relative to the north property line. Again, given that condition, given that this is again one of the things that we are encouraging everybody to do, to be prepared for an emergency, to raise that mechanical equipment. Again, if it was at grade, it wouldn't even be a question, but because the stand is a structured in the setback, that's why we're here. Staff is recommending approval.
All right, thank you, Robert. Do we have anybody here in opposition to the application for 2 King Street? Seeing no one, do we have the owner applicant here? Anything you'd like to say to the board? Okay, we're any questions for the city? Motion?
I'll make a motion for approval.
Okay, moves to approve. Mr. Morrison seconds the motion. All in favor, please say aye. Aye. Any opposed? None are opposed. The motion passes and the variance for 2 King Street is granted. Thank you very much.
And just for the applicant, we can then begin to look at the permit on that after the appeals period is closed.
All right, the final item on our agenda, B3, 519 Rutledge Avenue, West Side, Council District 6, TMS number 460-07-02-219, Zone DR1F, requesting a variance from section 54-301 to allow a new single-family home with a 3-foot 2-inch rear setback and a 2-foot 7-inch north side setback, 25 feet, and 3 feet are required. The owner applicant is Benjamin W. Randall. Mr. Summerfield.
Mr. Chairman, members of the board, so you can see the property here off of Rutledge Avenue. It is a property that does have other existing residential buildings on it. There is an existing, you can kind of see it here in the aerial, and then in the footprint, there is an existing structure there. This structure would be removed to allow for a new dwelling unit. This is not an accessory dwelling unit. It is a new single-family home, which is permitted by the DR1F. This will bring this property up to 3 dwelling units on the property, which means that this dwelling unit, as I understand the rules, will require it to go through our technical review committee as a part of its review. So it will have some additional review responsibilities that it'll have to go through. But you can see the lot here on the survey that was done. Again, for whatever reason, it's not showing on here the existing building that is removed to take the place for this house. You can see the main house fronting out on the relatively narrow lot frontage, if you would, on Rutledge. And there's a small home on the plan here that you can see here. And then this would be the area where the new home would be built. There is a footprint here, but this has all been demoed for a new development that will be going in on Nats Court. All right, so this is a relatively small house, in a different context, you might almost call it a garage apartment. But because it is, allowed to be its own, unit instead of as an accessory dwelling unit. So you basically have a structure, again, because of the, flood district, you couldn't do anything at ground level really other than the proposed garage with utility storage and what have you. You would enter off of the side, come up to the 2-bedroom, second story. Again, it's just a 1-story home. Here you can see some pictures that give a perspective on the current lot. And again, this is additional housing. The zoning allows for it, given the development pattern in this area, that yes, this is a variance because it will exacerbate existing conditions as to that existing building. Staff doesn't find that the request, given the nature of the lot configuration and everything else, is inappropriate, and that this is something we would recommend for, again, in this unique circumstance of this lot.
All right, thank you, Robert. We don't have anybody in opposition to this application. Do we have the owner or applicant on Zoom?
They are on Zoom, yes.
Is there a way to permit them to make a comment if they'd like?
Yeah, we can ask them to unmute. Mr. Randall, you should be receiving a request to unmute on your screen. Mr. Rivers, if you would like to unmute.
Unmute.
Yeah,
Good afternoon, board.
Anything you would like to add regarding your application?
I'm the architect representing Mr.
There's no requirement for you to comment, but if you'd like to say something, that's fine. Does the board have any questions? Maybe we ought to start with that before we. All right, no questions for the city, no questions for the applicant. Hate to deny the applicant the right to speak. However, not sure they'll be prejudiced. So do I have a motion?
Move approval.
All right, Mr. Morrison moves to approve. Is there a second?
I'll second.
All right, Mr. Huey, you got in there first. All in favor, please say aye.
Aye.
Any opposed? None are opposed. The motion passes. And the variance for 519 Rutledge Avenue is approved. Thank you.
Thank you.
All right, the meeting is adjourned. Thank you.